Welcome to our video series, Data Act Unlocked. In this series, we provide a concise overview of the most important provisions of the EU Data Act. In this episode, we will take a look at how data access and data use will be regulated by Chapter 2 of the EU Data Act. This is relevant considering that the EU Data Act reforms the access to and use of machine-generated data. In order to understand the data access regime in Chapter 2 of the EU Data Act, it is important to keep in mind the problem that the legislator wanted to address with the provisions on data access, which is the allocation of access to data from connected products. Currently, product manufacturers have de facto control over how and by whom the data generated by their products can be used. This is because the manufacturer decides how the product is designed and who can access the data generated by the product. For example, let's take a car. A modern car collects a vast amount of data about its use and environment. By driving the car, the user contributes significantly to the generation of data. Nevertheless, only the car manufacturer can typically use this data because the manufacturer effectively controls it and has technical access to it. If the user wants to access the data, they are dependent on the manufacturer, who can decide whether and how access is granted. This is where the EU Data Act comes in. Based on the fundamental idea that the user has generated the data through the use of the product, the EU Data Act assigns the data to the user. It places the user at the center of the data access regime and gives them various options for accessing the data generated through the use of the product. The first option is direct data access, set out in Article 3 of the EU Data Act. Based on the idea that the manufacturer's actual control derives from its design possibilities, connected products should be designed in such a way that users have direct access to the data generated through the use of the product. According to the principle of data accessibility by design, connected products must therefore be equipped with an interface for direct data access in accordance with the EU Data Act. If direct data access is not possible, the user has a claim against the manufacturer under Article 4 of the EU Data Act to access his data, effectively as a substitute for direct data access. The manufacturer also appears to be able to choose not to implement direct data access, but instead to grant the data claim outright. Thus, Articles 3 and 4 of the EU Data Act enable users to access their data. In order to enable commercial use of the data, users may also request that the data be shared with a third party according to Article 5 of the EU Data Act. Thus, the third party receives a derived claim for data access. More details on these data access rights will be provided in the next episode of our series. And what data is covered by the access rights? First, the raw data generated by the use of the product must be made available. In addition to the raw data, metadata must also be provided. Data that has been pre-processed for the purpose of making it understandable must also be provided to a certain extent. However, derived data is not covered. Let's turn our attention back to the manufacturers. For them, the EU Data Act will bring another very significant change in data use. In line with the basic idea that data generated by a user should be assigned to that user, manufacturers will only be allowed to use product data in future if they have been granted by the user to do so in a data license. This is regulated rather hidden in Article 4.13 of the EU Data Act. To wrap up, here are the key takeaways from this episode of our new series, Data Act Unlocked. The EU Data Act places the user at the center of the data access regime. The data generated through the use of the product is assigned to the user. This is the basic idea behind the data access regime set out in Chapter 2 of the EU Data Act. For this assignment, the EU Data Act contains three mechanisms. First, IoT devices shall be manufactured in such a way that they allow users direct access to product data. Second, if this is not possible, users are granted the right to access their product data. Third, this right can also be granted to a third party. Another key takeaway from this episode is that manufacturers will only be allowed to use product data in future if they have been granted by the user to do so in a data license. We're glad to have you following our series Data Act Unlocked. For more insights, check out #CMS Data Law or visit our website.